We are going to talk about the future of the profit allocation rules from an international, from an EU, from a Swiss standpoint. And at the same time, we are going to talk about transparency and capacity building in tax administrations with respect to the application of profit allocation rules, because we've seen in the last panel, especially with respect to amount A, if the new system has to go through, then the tax administrations really need to be trained for that, and they need a lot of training for that. Because there's an interlink with the separate entity approach. They will need training not only on the arm's length principle, but also on the amount A rules, the way they function. So against that backdrop, I would like to introduce our panelists to you for this event, for this session. So we have Dr. Richard Collier, who doesn't really need an introduction. He was been with the OECD as a senior advisor on the digital project, as well as a senior research fellow. He's a senior research fellow at Oxford. He's written a fantastic book on the arm's length principle, which I read at least 3 times, and I quote extensively in the research that I do. So I'm a big fan of Richard and his writing. We have then Mr. Bruno G. who also doesn't need an introduction. He's a fantastic speaker, and he's spoken in several events. And whenever he speaks, I'm really excited to listen to him. And he has a lot of interesting points that he's going to bring out today from an EU angle. And what are the big future issues going to be in the EU? We have Geert Stuer from the Belgian Tax Administration, who I've been interacting with since the early part of this year, since he had invited me to present do a session for the Belgian Tax Administration. So thank you for that, Geert. And it's great to have you back here. And the discussions we've had on a lot of international tax issues have been fantastic. So I think you're the right person to address transparency and capacity building. And we have at this, from a Swiss side, we have Dr. Natasha Martinez, who I also know very well. We used to share an office when we were doing our PhDs at one point in time, and we've been friends since then. And she's also a very good speaker, and she's very well known in the Swiss community. And she heads up the team on transfer pricing in Switzerland at the Federal Tax Administration level. And we have a colleague also who is a rising star in international tax and transfer pricing matters in Switzerland. It's Thibaut. So thank you all for joining us for this session. And with this introduction, I would like to just hand over the floor to Dr. Richard Collier to address some strategic issues with the income allocation rules that he would see going forward.
Well, thank you, Vikram, and it's a pleasure to be here, and thank you for the invitation. The mission you gave me was to talk about the big issues in profit allocation and how policymakers might resolve them. Well, I better start by confessing failure to meet that mission. I'm not confident that my choice of the issues would be agreed by all those attending this meeting. And I think anybody talking about how we resolve some of these issues is going to be very, very hopeful, given the uncertainties that currently cloud the horizon. The overall message in response to the brief I have is I'm going to be talking about the ALP, the arm's length principle, which I basically take to be a reference to the profit allocation rules. And what I'm going to be arguing is that that system of profit allocation under the international tax system is under more pressure than it's ever been. And it's very hard to see how those pressures are going to be resolved in a way that leaves the traditional hegemony or dominance of the ALP system intact. This is obviously a personal perspective. Now, I'm not saying that everything is pessimism and gloom. It's a fact that there remains strong support for the ALP system on the part of many states. It works well in a very large number of cases. And it's also the system that we have, which counts for a lot. And there's no serious push currently to get rid of it in its entirety. But nonetheless, there are problems and perceived problems at a number of levels. And I think, and I'll be suggesting, that these will have more of an effect as we go forward. So I'm just going to know if I could ask that we just move over the slide to slide 2. Now, in 15 minutes or so, I can hardly scratch the surface of what I've chosen to talk about, let alone pursue the topic in great detail. But I'm going to shape the talk by really focusing on two different types of current big issues that I think face the ALP. Firstly, there are what I would regard as internal challenges or internal issues. These are issues that affect the operation of the system as it stands. And in a moment, I'm going to give an example of each of a conceptual issue, a technical issue, and a practical issue that I see as significant. These are just examples. I actually think there are plenty to choose from, but they're examples of what I think are challenges or issues within the system. I'm also going to comment on what I regard as external challenges. And these are what I see as existential threats to the ALP from outside the ALP system. This is, for example, typically the impact of reform, international tax reform, that undermines or overrides the ALP. Obviously, probably the key thing is the relevance or the importance of the destination or the market location as an applicable factor or principle behind the allocation of taxing rights. That's an example of what I would regard as an external challenge on the ALP. But let me start with the internal challenges. Internal challenges and issues I see existing at various levels. In particular, I've chosen an example at a conceptual and a technical and a practical level. Now, the conceptual example I've chosen is the value creation issue. Value creation since BEPS has been proposed as a core principle or paradigm of the ALP, and it's generated an enormous debate. My own view is that value creation, the notion of value creation, doesn't encapsulate the existing system. For example, it doesn't really tell us how we deal with capital under the existing system, doesn't really explain how we take account of market-specific features in our comparability analysis, and so on. There are a number of other examples where it seems to fall short of explaining what we do in the transfer pricing guidelines. So it's not very good at encapsulating the existing system, but nor, it seems to me, is it a particularly useful normative standard for the ALP. It's vague and unclear, and just to show how malleable it is, how easily it's pressed into service of anything, maybe I can just remind you that the European Commission used the value creation notion to justify a turnover tax. So my first thought when I started looking at value creation a few months ago, following BEPS, is that this was something of primarily of academic interest. It really wasn't that particularly helpful. But the reason that I've chosen it today as an example of a conceptual challenge to the ALP is that my thoughts have changed, and I see it as having much more of a practical impact in a way that I think is actually unhelpful and misleading. And in a few moments, I'm going to go back and give you an example of just that, where I think the value creation is causing unhelpful practical impacts on the way we operate the ALP. Now, my example of a technical challenge would be in relation to the hugely significant BEPS reforms relating to the risk, making, I believe, the whole question of risk decisive in the location of profit. Now, this is something I've been working on quite a lot recently, and I guess the obvious question to raise is we've now had almost 5 years of practical experience following BEPS. And the question would be, in my mind, how the rules are working. I think in some respects, they're not working terribly well, or certainly not as well as they should. There are a number of unclear areas, there are disagreements on technical issues, and the application of the regime is very onerous. For example, the demands on understanding decision-making relating to the control of risk, especially in a matrix-managed business, seem to me close to impossible, certainly very difficult. My example of a practical challenge to the ALP is the complexity issue, which is I'm just presenting generically. It does seem to me that we have a very poor track record in managing, actually even addressing complexity within the ALP. We've seen the transfer pricing guidance doubled in length after BEPS. We're going to have another 100 pages or so once we add in our volumes, the profit split, hard to value intangibles and financial transactions work. And so it seems to me that we're on an inexorable advance in complexity and detail that's not going to realistically stop until the complexity issue is addressed in some way. Some states, they think they just cannot cope with complexity as it stands. And it seems to me there's a real risk that complexity makes the transfer pricing task unmanageable. Now, I just give you any isolated examples of these different points: conceptual, technical, practical. There are many other issues I think could also be explored. For example, the relationship between Articles 9 and Article 7 in the light of what I regard as the failure to deliver the intended meaningful clarification on PE attribution in the light of the BEPS changes. The general use of decision-making as a proxy in the allocation of profits raises all sorts of problems. We still haven't fixed the capital problems that we set out to fix in BEPS. So a whole range of problems. Let me just turn to the external challenges now. The obvious one is from the big debate in the work on digitalization. The finding there, I believe, is not just that the ALP does not help, but actually that the ALP is a core part of the problem. The emphasis, I believe, has been for a number of years on the inadequacy of the physical presence of nexus and, critically, of the profit allocation rules as doing a disservice to the overall state of what's required. I believe over time it's become clearer that that is a widely held view. It's not a unanimous view of states, but if we look at the three solutions presented by delegates a couple of years ago and the unified approach, they all go beyond the ALP and they all reject the separate entity approach. Now, it's true there have been attempts to bridge the gap between the current system and the policy objectives, and that's with ALP-style responses to digital. In other words, proposing features of the ALP system as a basis for a solution to the digital problem. But I don't think that really gets us very far. These types of solutions seem to be generally, obviously, non-arm's length, non-ALP. They're not ALP solutions, even though they're trumpeted as being ALP solutions. And they're extremely hard to reliably operationalize. I guess I'm saying I think they just don't work generally. So that makes them ineffective or unattractive. But also note that while this is the big issue, the big current issue, the digital challenge is not unique in turning away from the ALP. In BEPS, we've already seen reversals of policy away from the ALP. For example, Action Point 4 on interest, which reversed the policy in the mid-1980s on thin capitalization. The work on the patent box, which rejected an ALP response. And we see many other unilateral measures that have a similar effect. All of these things reflect some material unease with the ALP. Maybe we can move to slide 3, please. So what are the consequences of these types of challenges that I'm referring to? Well, these internal challenges, of which I think there are many, typically make the ALP system harder to operate in practice. They typically create greater risk and uncertainty in outcomes, and fundamentally, they undermine the integrity of the system, in my view. Now, take some of the issues I've just talked about. You can actually see how they're so easily linked. If you take the value creation issue, which I've criticized, I think it's true that the value creation issue is causing conceptual confusion in the application of the risk framework. I think it's been recently convincingly argued by Andrew Hickman, the former head of transfer pricing at the OECD, that this is causing mutations in application of the risk framework as the application in practice becomes a hunt for all possible risks as a factor of value creation, rather than what we should be doing, which is assessing if the threshold for the control of risk is actually met. So in other words, I see value creation as pulling us away from strictly operating what it says in the transfer pricing guidelines, and that obviously leads to difficulties. The obvious one is it's going to lead to technical dispute. It has led to technical disputes. Some states clearly agree with that style of approach, some disagree, and that's causing some acute difficulties in MAP and in other areas. It also creates complexity and uncertainty and has an overall destabilizing effect on the system, encouraging other mechanisms. So just this one example of value creation, I hope I'm giving you some sense how I see that creates the conceptual confusion. It feeds into the technical interpretation of the guidelines, and that creates all sorts of practical complexity difficulties. So that's what I wanted to say about as a sort of generality about the internal challenges. What about the external challenges? Well, the consequences of those, it seems to me, is that it might mean, well, actually mean, it will inevitably mean that the relevance of the ALP system is diminished. So if I come to the second part of my challenge from Vikram, which I'm most definitely not going to be discharged, what actions might I recommend to resolve these issues? That would be a brave person who recommends actions to resolve in this deeply uncertain time. However, my thoughts, for what they're worth, are in terms of how I would address the internal issues, it does seem to me that some kind of review of the actual operation and the application of the BEPS package, especially the material on risk, would be worthwhile after, as I say, 4 or 5 years of practical operation. I'd also suggest that the work on Article 7, the intended reform of the AOA, has not been effective, but was needed. Now, I know both of those suggestions I've just made are politically unattractive, given the AOA and the BEPS experience, but they do seem warranted. A third suggestion I'd make is that we need to change the mindset on complexity. My observations of what I see in practice is that there is relatively little support for addressing complexity, and most people are normally keen to tell you reasons why they shouldn't, rather than reasons why they should. My final suggestion on the internal challenges that I've been speaking about are that we probably need to be a bit more open to pursue different or supplemental rules, maybe inevitably non-arm's length rules, to deal with areas where the ALP does not work, such as capital, which would have the effect of supporting or propping up the system where it's weakest. In terms of actions on the external challenges that I see, well, I've already made it clear, I don't think the ALP has an answer to these, and it's not going to provide an answer. The ALP, I think, is clearly seen as part of the problem. And the mission, I think, forward is going to be to manage the interaction to avoid distortionary or excessive double taxation from competing or alternative tax mechanisms and their interaction with the ALP. My overall message, just before I conclude, is that there is unprecedented pressure on the ALP. I've talked about 2 types of problems or challenges that I see, the internal problems from the operation of the system, and I've tried to give you some examples of that, and the external challenges where the ALP is effectively being caught up in a much bigger discussion about the allocation of taxing rights. Now, I don't see these challenges as being fatal to the ALP, but I do think that they will increasingly undermine its standing in the international tax system as the primary mechanism for income allocation. Thank you.
Well, thanks a lot, Richard, for this wonderful opening presentation where you've really put across what are the internal and external challenges in the ALP in a very nice way. So that it's a very nice way of putting across the challenges in the profit allocation system. And at this stage, I just want to ask Natasha or Thibaut if they have any comments on Richard's presentation or any questions for him.
Yes, thank you, Vikram. Very interesting presentation. We heard a lot of difficulties with the application of the arm's length principle. We heard also that we can see that there is a trend to new solutions that are not in line with the arm's length principle. As a tax administration, I would ask the question to Richard. What do you think for the future for the tax administration? Do you think that these new rules that are maybe not in line with the arm's length principle will have the result to lead to more discussion with tax authorities or less discussion? What do you think for the future? What will be you talked about the complexity, but what will the complexity will be higher, or can we say that maybe with these new rules we can just find a solution and that the discussion will be easier with tax administration?
Well, I think you'd have to be very, very, very optimistic to think that complexity levels are going anywhere but up for about 10 different reasons. I think the really big question about the interaction of the ALP and whatever alternative system is put in place to deal with the digitalization issue, I think it's very hard to engage with that until later in this year when we've got a better idea of what's going to happen. But overall, the problems I'm talking about, I don't see a material difference between the difficulties caused or the fact that difficulties would be caused to taxpayers and tax administrations. I think both are negatively affected by the issues I was talking about.
Yeah, thank you for that response. Do you have a follow-up question, Natasja?
No, just maybe another comment. At the beginning of the presentation, you talk about some vague concept that we have now in the guidelines. So, for example, the value creation issue. That I think something that that we are discussing, and we have some interesting discussion. What would be here your position on what could help this new concept? What will be the tips that you can give to have a really discussion that is really focused on something that is less vague than what is described in the guidelines?
Well, no, I wasn't criticizing the guidelines. I was making the point that value creation isn't really a concept that's used in the guidelines. It's been, I mean, value creation was, I think, first used in the 2012 intangibles paper in the draft just before BEPS. So it's a relatively new concept. I guess my point was that it's as a practical matter, I see it more and more undermining the approach of the transfer pricing guidelines. In other words, I was trying to make the case that I saw a reliance on value creation as a notion that helps us as being illusory. I don't think it does help us in doing transfer pricing or applying the transfer pricing guidelines. So that's really the point I was trying to make.
Well, thank you for that, Richard. So I think with the internal challenges which you've put across, I think you've rightly spotted out that administration of these rules is going to become much more complex once you add the new chapters in the OECD transfer pricing guidelines, which will take it to around 750 pages. And then probably with the, with the UN TP manual being subsequently updated, there's going to be another 1,000 pages on the UN TP manual because they just usually copy paste the work of the OECD and add a few more examples. It's getting more and more complex. And at this stage, I would just ask Bruno if he has any comments on the internal or external challenges which Richard had highlighted.
Well, thank you, Vikram. I'm very much interested in what Richard said about complexity increasing. I do observe indeed in my practice that complexity is increasing and that the BEPS work has been, in my view, creating more challenges between countries, more double taxation. I'm of course happy with, I was in the panel of the Tax Certainty Day in September. I'm happy to see the progress of the OECD on MAPs, dispute resolutions, but still I'm very much concerned about indeed the complexity, about increasing the fight between countries as regards taxation, cross-border taxation. One point I would like to underline, which is a positive one compared to what I just said, is about, I was very impressed about what the OECD achieved with the COVID situation and the guidance which was given to private practice and tax authorities with the publication of first in April last year, guidance about treaties, and in December last, guidance about transfer pricing, which was, I understand, updated and completed just a few days ago. So this is a very, very important thing. And if I may say, in this guidance, of course, it is not as precise as we would like to, as practitioners. But however, we often think that OECD guidance is rather vague. I thought that in this COVID analysis, you were going rather far away and you were rather precise. So thank you very much for this.
All right, so with these opening comments, I think, Bruno, we will move to you now for just giving us the European perspective on what are the future big issues you see in light of the backdrop of the internal and external challenges that have been put forward by Richard.
Okay. Thank you, Vikram. Happy to be there. Yeah, EU perspective. As we know, EU has always been interested by transfer pricing. You may remember the creation in 2002 of the EU Forum on Transfer Pricing that I had the privilege to chair until the last session in 2019, and which enacted a variety of guidances, soft law, of course, but guidances on dispute resolution, APAs, transfer pricing documentation, and so on and so forth. And more importantly, if I may say, since the last few years with the financial crisis, as we all know, the EU Commission has been in a position to have a variety of directives to be adopted very quickly, and most of them deal in a way, directly or indirectly, with transfer pricing. So EU has become, I believe, a real key player, and of course, we must see how it works vis-a-vis the OECD. We have, of course, also another actor than the Commission and Council. We have the ECG, which is adopting regularly decisions which have consequences on transfer pricing. So I will try in this presentation to very shortly remind what took place last year, 2020, and more focusing on what I was asked to do, maybe, is to try to have a focus on foreseeable TP issues in the future. If I go first to the development which took place in 2020, we have two kind of developments which may require a few words. The first one on the next slide is about EU case law. We have had indeed, I think, 3 interesting case law which took place last year by the ECG. One about transfer pricing applicable between a foreign headquarter, Italy, the case, and a branch in Romania at the case, and whether a different rule applicable to a cross-border situation was acceptable. It's not completely new. We already had a similar case law in 2010 at GI, but it reminds again that yes, special regulation for transfer pricing may infringe the fundamental freedom. However, in this case, it has been considered by the court that it is proportionate and that it is necessary to ensure a proper balance of power to tax between member states. The second case law, which is interesting, which took place last year, is a case law about international exchange of information. It is an October 2020 case. It is a case between Spain and Luxembourg, and it looks again to the right to remedy which must be granted to the taxpayer concerned, but also, and it is what is interesting in this case law, to a third party to whom questions are put in order to examine the situation of a given taxpayer. Indeed, very often, and it is the case in this case law, the Spanish authorities requested information from the Luxembourg authorities, and the Luxembourg authorities had to put questions to a third party to collect information regarding the taxpayer under examination in Spain. And this case law addresses the rights of the various persons who have a remedy. It is not a completely new case law. Also, you had a very interesting case law Berlioz in 2017 on the same issue about the conditions to apply the exchange of information. The last case law on the following page, which is interesting, I'm pretty sure it is very well known. It is a case law not of the ECG, but of the General Court, EGC. It is a case law about the Apple case. You remember, of course, the actions on state aids taken by the Commission against a variety of companies, one of them being Apple. And the EGC rendered its decision in July last, saying that the decision of the Commission was not grounded. That is to say that the Commission had not brought the proof that the ruling which had been applied to Apple was not consistent with the arm's length principle. What is very interesting in this is that, independently of course, the case at stake, is the fact that the EGC recognized the arm's length principle, and more importantly, mentioned that the application of the arm's length principle must follow the OECD guidances. So it is a very interesting case. Of course, an appeal has been lodged by the Commission on 14 December 2020, so it is not the end of the story. So this is for the case laws. As regards now the legislative developments which took place last year, two things to mention. The first one is about the directive of October 2017 on dispute resolution, which is in force as of 1st July 2019, and which has been implemented now in member states. We, however, don't have, of course, feedback on how this directive is working because it was applicable only to cases of double taxation as of tax year 2018. So it's still recent. So we don't have cases. We, however, know that it is in place. It has been put into internal law, and also many countries such as France have designated their experts, independent person of standing. I'm happy to be one of them, by the way. So I'm looking forward to be convened, I hope, in one of these advisory commission of the directive. So just to mention, and then there is the taxes directive, which is a directive which is not very recent. As we all know, it is a directive of 2018, but it was applicable as of 1st July 20. There has been postponement because of the COVID crisis, optional postponement, which lead that the first, if countries have opted for the postponement possibility, the first reporting will have to be done. On 28 February 2021. That's what France, for example, opted for. This concerns the first period, that is to say, all the schemes falling into the hallmarks of taxes between 25 June 2018 until 30 June 2020. Because even though the directive was in force only as of 3rd July 2020, it retroactively applied to the cases falling into its scope as of 25 June 2018, which was rather a curiosity, I would say, but that's what it is. And then there is a 30 days deadline to report the schemes, which was to apply as of 1st July 2020 and has been postponed optionally as from the 1st January 2021. So this directive is now in place. The first reporting must be done. This directive addresses transfer pricing issue. You have indeed special hallmarks, category E, which concerns transfer pricing. There is a question, I have not the answer to it, but there is a question which is not, in my view, addressed in this directive, which is whether this applies in the relationship between a head office and a PE. Some countries, such as Belgium, I think my colleagues will mention that, I've taken a position clearly on that, saying yes, it applies. I think the Netherlands also have done that, but it is not completely clear when you look at the directive. So this was just to remind in the first part of my intervention, to remind the main things which took place. Now I'm going to turn to the foreseeable future, what we can expect to see in the EU. We can see a variety of things, in my view. The first one is the consequences are the accompaniment by the EU of Pillar 1. We, of course, this has been discussed at length in this conference in the previous panels, but we expect, of course, to have a deep impact, and not only in the digital economy. We know that the EU has been proposing initiative in the digital economy as of 2018, and in 2020, there is also a Digital Service Act package in December last, which has been adopted, and there is also a position which has been taken about resources for the EU, that is to say, to increase resources, autonomous resources of the EU. You know, it is a very important debate within the EU to increase its own resources, not resources coming from member states subsidizing or contributing to the EU budget. And the digital levy has been looked at as one of them. This will be put to public consultation in the first quarter of 2021. An interesting thing, an interesting development on the following page as regard Pillar 1, or more importantly, digital economy, is a rather significant case law in France. I think everybody or most people know about the so-called Google case. Google case was a very important case law which defeated the French tax authorities about recognizing a PE in the GAFA organization, service company in France. The French tried to consider that these services company were PE and were defeated in court. But the Google case was settled publicly, so it is out of the table. But, and we did not have because the file did not go to Supreme Court because of the settlement, which is public. But there was another case, less famous, but important, Value Click, now called Conversant. The company changed name. And the appeal court had ruled in the same direction as Google, that is to say no PE in this situation. But this case was not settled before going to Supreme Court. It went to Supreme Court, and in December last, French Supreme Court reversed the position and said, yes, in the situation of Value Click, Conversant, which may be similar in other situations, is to say when you have a service co, which is, however, making the main business as regard contracts, even if you have guidances from outside, from the head office, from the parent company, even if you have a little margin of decision. However, Supreme Court considered it is a PE. So it is a very significant point for a variety of reasons. The first one is, it is because of the Google case that the French government went to the digital tax because they thought they could not tax the digital economy because they could not characterize PE. Now, apparently, they can characterize PE. So we may have both the digital tax, because as you know, it applies in France and in other countries, and at least in France, PE characterization. So it is very significant. Another important point is that the French Supreme Court reversed also its position as regards the OECD comments. Before Supreme Court considered that only comments or OECD comments before enacted before a situation was applicable, and not new comments, no ambulatory interpretation. and they reverse this position in this case law by analyzing the new OECD commentary to take their position. So it is very, very important case law in my view. We don't know yet, of course, what the tax authorities will do. They announced that they are going to look at that very thoroughly to see what conclusion they will draw on this.
Sorry, just a question here, Bruno, if you don't mind, since we're talking about the digital economy debate, and just wanted to ask you in this value click case, did the French Supreme Court also speak about how do you go about allocating profits to the dependent agent permanent establishment or not? Or
That's a very good point, Vikram, because we all know that it's very well to know if you have a permanent establishment. Okay, good. Then when you have decided that you have a permanent establishment, you still have most of the work to do. That you say, what is the profit you are going to allocate to this permanent establishment? In my view, the only possibility, of course, is to follow the OECD approach, that is to say, to see what are the functions and risks of the PE. But we all know that we have the first legal point, whether a PE or not, and then what part of the profit to attribute to this PE. If I go to the next topic of the future, about following slide about the dispute resolution. As I said already, it is a dispute resolution directive. As I said already, there is no case right away. Two interesting points to mention maybe. The first one is that you know that when you convene, it was assigned with the arbitration convention. For each case, when there is a case going to the advisory commission, you have to settle an advisory commission. You have to choose experts in the list of the countries, and you have to settle also a secretariat to handle the case. And which is, I've been a member of two already from the arbitration convention in two advisory commissions, and it's always a very burdensome process. You know, you have to build everything from scratch each time. And I know I had a discussion with TaxSud. Member states, some member states at least, are considering creating a permanent secretariat in order to administer this advisory commission. In my view, it would be a very good idea, but it's still under discussion. But it is good that it is discussed. I do remember at the very start of the EU forum that I chaired, when we discussed that in 2002, member states were very much opposed to that. So it seems very good to me that maybe nearly 20 years after, it seems that member states or some of them have moved their position. The second item I wanted to touch base is about Brexit and the arbitration convention, whether it will still apply. It is a rather difficult issue to decide because arbitration convention is a treaty. So it is a treaty based upon Article 2020 of the EU treaty, but it still is a treaty. So it is independent, in my view, from EU law. However, if you look at Article 16 of the Arbitration Convention, you see that it refers to the EU territories of the member states. And as a result, the UK is not any longer, it is quite paradoxical because I think that the treaty could remain in force because once again, it is a treaty between states, not necessarily member states. But given that Article 16 refers to the territory of the member states of the EU, it refers to Article 27.1, then it would not apply. But it has not been clarified to my knowledge. It would be interesting to clarify whether the arbitration convention, which is still applicable notwithstanding the directive, you know that we have still the directive, the new directive I mentioned already, and the EU arbitration convention, the two legal instruments continue to work together. So given that the UK is withdrawn from the EU, directive should not apply. However, arbitration convention might apply, but there is this uncertainty I mentioned. If I come to the following item, I think I might maybe a little speed up in my presentation. You know that we have this very old story of the CCCTB and which has been turned, dropping a C as a CCTB, common consolidated tax basis or just common corporate tax basis. This was in the work program of the EU of January 2020. However, In June 2020, there was a statement of the European Council, which states, I have put the quote in the slide, which states that it should be put on hold, but could be resumed once international negotiations, in particular those regarding the OECD's global anti-base erosion proposal of Pillar 2, have been concluded by the end of 2020. It's not the case. So for the time being, this is a situation of CCTB or CCCTB. In my view, it will be very important to have CCTB as regard Pillar 2, because if we have a minimal rate of taxation, we should have, of course, a common base of taxation to appreciate this minimal rate of taxation. This is on this very old project of the EU. Another well-known project is the public country-by-country reporting. You know, it is a goal that the EU has been pursuing. A directive had been proposed in 2016. It had been blocked in a ECOFIN council, in a council, not an ECOFIN one, a council of December 2019. However, last 13 January, very recently, the Portuguese presidency has put again a new proposal, not very different from the former one, by the way, but a new proposal to be examined. And it is, by the way, it is today that the working party must, at the EU level, must be examining for the first time this new proposal. So maybe we might have some development in this regard. The last item I wanted to mention is that an action plan was adopted by the EU Commission in July last, and 25 measures were introduced. And one of these measures is to create a new expert group on transfer pricing. Once again, to elaborate, I put the quotation, pragmatic, non-legislative solutions to practical problems posed by transfer pricing in the EU. The group is clearly, it is a kind of new EU forum. I reminded you of the EU forum from 2002 until 2019. The EU forum has not been renewed from this date. However, TaxSud is considering they do need to have an expert group on transfer pricing. That transfer pricing is still a very important topic at EU level, and they do need to have an expert group. This expert group, its structure is still under consideration. They are still wondering whether they are going as a EU forum to be private practice members or not, what kind of topics they are going to address, these kind of things. Several topics might be addressed according to discussions I had with TaxSud, such as MIP, such as cooperative compliance, Pillar 1, of course, also. And also maybe the profit split. You may remember that the last report that the EU Forum had produced in March 2019 was about profit split, but it was not at all a finalized document. It was just a first document. So it could also be one of the topics to be addressed. But what is interesting in my view, and I had a discussion with the head of Bible of C2 unit in TaxSud in charge of this, and they do believe they do need to have once again a group to help them to work in the field of transfer pricing. And that's it for what I wanted to explain to you, more or less in the time I was allocated.
No, thanks, Bruno, for these comments for the future of what's going to happen or in the European Union in the next few years or so. Geert, do you want to comment on any of the specific points raised by Bruno?
Yes, I would like to ask a question about the DAX 6, but because indeed, like Bruno explained, the hallmarks are rather, not that always that clear, but it's also the purpose of the hallmarks. They're supposed to be very broad-widened, and of course, then the effect is that all the countries have to come with some kind of explanation how they will implement those kind of things. So, and indeed, like Bruno explained, there are differences between the countries. And I was wondering, how can we deal with that? Because how can we make sure that there comes more tax certainty on that? Do you see solutions on that? Do we need to have more transparency or more publication? Do you see a solution on it? Because I do believe it is a problem, but how will we deal with that?
It's a very, very good point, Gerd. From the beginning of these taxes, you know, the problem, I think, that EU Commission considers that a directive, a directive, of course, in the field, in the scope of competence of the EU. So they enact a directive, right? The directive is adopted, but then they consider that when it is adopted, it has to be implemented by member states, yes? And so it is to member states from the directive which has been adopted by EU Council on a Commission proposal to adapt it into their internal law. But I think that in such a case as taxes, we would most certainly need to have common interpretation. And I think we really should have, you know, I don't know, working group organized by the EU Commission or by the Council, I don't know, where countries could exchange their problem of interpretation in order to have a common approach. Because if it is not the case, particularly given that taxes can apply in several EU countries for the same organization, for the same operations. I'm currently in my practice working on an organization touching several EU countries. And so the question is how reporting is going to be done by the various taxpayers or intermediaries such as me in the various countries, and the interpretation is not necessarily exactly the same. So I do believe, in my view, but I don't think, I've not re-put the question recently, I don't think it is considered by the EU Commission. I think it would be good to have a group where at least, even if it is not formal, but where problems could be discussed, divergences of interpretation discussed, in order to find common approach.
Yes, I think you have a good point. And I'm hoping that some kind of working group, maybe in the TP expert group, it comes to
yeah. Maybe the expert group, yes, I mentioned, yeah.
It's a good point. I also had a question about the public country-by-country reporting, because I know in the Parliament we're always discussing about it, but in the real life, business are already publishing their country-by-country report. So will that not be the future? They will report it on a voluntary basis. We don't need that kind of laws. It will just happen.
I tend to also to agree with you, Gert. I think that well, there is no compulsory legislation except for financial institutions, as we know, to publish. But what we see more and more indeed is that MNEs, multinational enterprises, are indeed publishing a lot of information, more or less what is in the country by country. And I think it is my own personal interpretation. I know several companies are opposed to this in several countries. But I think that the trend is, you know, the trend of transparency, of publication. I don't think you can fight against it. So but it is only my own view that this will go forward.
Thank you, Bruno.
Okay, so thank you, Geert. You know, just on the value click case, where dependent agent permanent establishment was constituted in France as a result of the dependent agent. I would just like Richard to step in here and, you know, just express his opinion on allocation of profits to a dependent agent permanent establishment, because the entire debate is, you know, once you have a dependent agent which has been compensated under Article 9, here I'm assuming the French local entity, then there should be no further income attribution to a DAP. But Richard, what is your take on that?
That was a lot easier to answer before the BEPS reforms of transfer pricing. So before that, if we were just looking at the AOA, I would say that there would be situations where the return under the Article 7 AOA would clearly be greater than the return under the Article 9 approach. The difficulty following the BEPS changes is that well, a whole number of very specific technical difficulties, but the primary one is that and I've referred to this in my comments, is that the the intention was that there would be further clarification about how the PE attribution rules worked under Article 7 in the light of the BEPS changes, particularly for risk. And underlying all of this is a question about how we reconcile the control of risk provisions in Article 9, that version of the ALP, with how we approach the decisions to, the active decision making in the AOA or for Article 7. And that was an attempt was made to do just that in the first version of the attribution of profits guidance. That was, I think, about 2016. And unfortunately, my view is that although that was a very complex piece of work, it was actually required. But unfortunately, that failed, and we ended up with subsequent guidance, two versions of the two drafts subsequently in 17 and 18, which I'm afraid didn't really answer any questions. So this is a very long way, Vikram, of saying that your question is unanswerable based on current guidance. Now, I can certainly tell you what I think about it, but we'd need another 20 minutes, which we haven't got.
No, I think what we will do is we'll move to Natasia's presentation, and we will come back to a few other questions that have been raised in the Q&A box. So Natasia and Thibaut, the floor is all yours.
Thank you, Vikram, and thank you again for the invitation. So I will do this presentation with Thibaut, my colleague, who is a TP specialist of the team. We will discuss the Swiss perspective on transfer pricing, and we will give you some information on what has happened last year, so in 2020, with regard to transfer pricing in Switzerland. On the next slide, you can see the agenda. Yes, thank you. I will start to present briefly what has happened on the TP front, and then as a representative of the tax administration, we will give you some information about the transfer pricing key issues we had during audits, and also within the assessment of rulings request. Maybe for those of you that are not familiar with the Swiss system, what we call ruling in Switzerland is more known in other countries as the unilateral advance pricing agreements or unilateral APA. I will come back to that tool in a few minutes. And finally, we will give you some thought on what will be the future outlook in Switzerland on MNE profit allocation. Thank you. You can go to the next slide, and here I will give you first some general information on our organization, but also on the main topics we discussed in our work and on the work completed in 2020. So as previously mentioned by Vikram, I left his office a few years ago to work for the government, the Swiss government. I worked first for the State Secretariat for Financial Matters, mostly on BEPS. And after that, I took the responsibility of a transfer pricing team at the level of the Swiss tax administration. This unit was actually quite new, so it was built in 2018. And first information on the organization is that the team was fully operational in last year in 2020, with people having different backgrounds and having different knowledge. So we have people that are economists, lawyers, tax expert, and financial analysts. So we have some very interesting discussion, and the tax administration is also having a team that is now completely dedicated, fully dedicated to transfer pricing. So that's the first point here, first information. Second point is that last year we had to deal with the new chapter in the guidelines, so the chapter 10 on financial transaction. As you know, the Switzerland is an OECD member and is applying the OECD guidelines. So we we are relying to the guidelines for the application and interpretation of the arm's length principle. We had some very interesting discussion already in 2019 with the taxpayers, but I think it really became a central topic for us last year, especially in the context of ruling requests. So Thibaut will give you some details on that later, but I can already say that Chapter 10 gave us a common basis to discuss with taxpayer, but also new challenges, because we had on the table a new discussion on topics that were not included in the guidelines before, especially something that was really important for us and discussed a lot is the question of the implicit support. So we will come back to this later, but just a general comment here. I think it was really positive to have a new chapter in the guidelines on financial transaction, because it was not the case before. So a common basis to discuss, but also a new discussion and maybe more complexity on some topic. Maybe that's the trend, but I don't know. We can come back to this later. Then here you can see that we also had, we did a lot of ruling requests. As I said, ruling are not something that are just unilateral APA, and they are not granting any privilege to taxpayer, but the main objective of rulings is to confirm tax consequences of intra-group transaction, in future intra-group transaction. And in that sense, I think we can just say that they validate the application of the law in a specific and concrete case. Ruling, they are unilateral, so unilateral APA, they can be opposed to bilateral APA, but they still grant certainty to the taxpayer. But because they are unilateral, so they are just involving the Swiss tax authority, and the certainty will be limited on the Swiss side. So the question here could be why some taxpayers want to have a unilateral APA if there is only a limited certainty that is granted by this by this ruling. And I think the answer here is that maybe so it takes less time than a bilateral APA, and it can be preferred by taxpayers for some time constraints. And in addition, we saw last year that we had a lot of rulings dealing with financial transaction, and the discussion is based on the OECD guidelines. The solution or the answer, the ruling, is also based on the OECD guidelines. So it still, in my view, brings some kind of certainty to the taxpayer. Also on the other side, when the taxpayer is discussing with the other country, because we were just applying what is in the guidelines. Then some statistic also. So what does it mean in terms of numbers? We had 89 ruling requests last year. Some of them were approved, some of them were conditionally approved, some of them were rejected. Here the process to obtain a ruling is based in Switzerland on an open discussion between the tax authority and the taxpayer, where all the documentation required should be submitted by the taxpayer. And then we will have a discussion, and the taxpayer will receive an answer from us. Maybe a comment on what is conditionally approved. So we have the majority of rulings that are conditionally approved. So here it's when we are just putting some reserve, or also it includes also the rulings where we found an agreement, but where the validity is limited in time. So I will be finished with this slide, and I will leave the floor to Thibaut, who will explain in more detail what were the challenges in the audits, tax audit, and also in the ruling request last year.
Good. So thanks again also for the invitation. So now I will talk about the different issue we are dealing with during the tax audit, but also during ruling request. So an important topic is actually the characterization of the entity. And I know that this is not a new topic, but actually this is still a topic for challenges. And I think that this will be also a topic in the future when there will be more and more tax audit of financial years that were impacted by the pandemic, because then the question will be what kind of functional and risk profile do we have, and then do we have to share the loss. So these points were already discussed in previous session, but I think it will be still an important topic in the future. And then as Natasja mentioned, also as a result of the new chapter 10, there were a lot of new challenges or area for challenges. So for instance, we have the delineation for financial transactions. So meaning that, of course, nowadays, we also focus a lot on the terms and conditions of the transaction, and not only on the pricing or the interest rate. And actually, that might be also a reason why in ruling requests sometimes we receive, and actually it's also a trend, we receive more and more, let's say, straightforward transactions. So maybe they want to avoid also further discussion on the terms and condition, and so that we focus on the pricing. Then, of course, after based on the chapter 10 now, we have also more guidelines regarding the methodology to estimate credit ratings. And actually they made clear statement that there is a strong preference to use, let's say, credit rating agency methodologies and less the black box software available like RiskCalc or others. And then and that's a key point, that's also the implicit support is actually a real hot topic for the moment, and we experienced that already quite a lot during ruling request review, not tax audit, because this will come more in the future. But there is an explicit reference to the implicit support in the OECD guideline, but this is still a gray area. Why? Because actually there you have two questions. You have, the first thing is to assess whether you have such implicit support, and that's already a challenge. But the main challenge is when we actually agree on the implicit support, then we have also to assess what's the size of this implicit support. And there are several guidance published by the credit rating agency, Moody's, S&P, and they don't have, there is no consensus. So they have also a different way to approach the implicit support. So that's why also this is a topic, still a hot topic, and this is a gray area still. Then also this year, we also faced other challenges also during ruling requests, because we received a lot of requests for the value of some intangible or the value of some shares. And there actually, because of the pandemic, then we face also two challenges. The first one is, of course, whether the data provided or used for the valuation include actually the impact of the pandemic. And actually this could be the case for several years, right? And then the other issue or the other concern was also about the certainty regarding the data, because then it means that in the future we may the data actually may not reflect the future, because we have more uncertainty currently. So this may also need to be considered in the valuation. So then we listed some trends we also saw recently last year. So an increasing use of the multiple period excess earning method for valuation. This is a kind of, let's say, discounted cash flow approach, but this approach was not really something we saw in the past. That was not a common practice, but nowadays we see this more and more. Then more centralization of IP. I think this is also the result of all the BEPS initiatives. And then an interesting point, and this was also discussed a bit yesterday, we also see more and more cash pool model, where actually the cash pool leader is assuming more limited risk compared to the past, where there was a kind of the bid-ask spread was left in the cash pool leader side. Then here we see more and more cash pool leader acting more as a kind of a service of or intermediary companies, financial intermediary. So this is also some new trends we see. So maybe next slide, please. So actually, as I mentioned also here, a lot of Swiss companies, like in any countries, were impacted by the pandemic, directly or indirectly. Directly, I mean, they had to close their office, they had to stop the business, but also indirectly because maybe we have also several headquarters in Switzerland, and maybe then their subsidiaries were impacted by the pandemic. So there, as it was mentioned also during some session yesterday, then of course some group decided to adapt the transfer pricing model to address the impact of the COVID. And there the question would be in the future, when we will review these financial year, whether these changes are temporary or permanent, because maybe then they will keep this model, this amended model in the future. Then the question is whether the changes are actually in line with the arm's length principle. And it could be also the opposite, that actually a group decided not to do anything, but then is it something, an action that makes sense from the arm's length principle, or whether they should have done something like an independent company. And there, I think that's something in our view very important. We still need to stick to the arm's length principle. That even if it's a specific or exceptional circumstances, then we still need to stick to this principle. And what I mean by that is actually we will have to see what third parties did in a similar circumstances. This is important. And then, of course, here, that's always the issue with the arm's length principle. There is a kind of a time lag, of course. And then, of course, what is important is to make sure that the functional and risk profile of the companies remain unchanged. So it's not, and this is mentioned actually also in the guidance of the OECD about the pandemic, related to the pandemic. It does not make sense that suddenly the profile of the company changed during the pandemic. I mean, we should still have the same functional and risk profile. So this is important. And then, of course, make sure that the pandemic is not used as let's say, as an opportunity to make some tax planning, but if there are any restructuring project, of course, it should have an economic rationale behind that. So maybe next slide. So actually, then my last point is actually we will see, given that a lot of group, especially in some industry, were significantly impacted by the COVID, then in the future we expect that there will be more and more restructuring project as a result of that, maybe to improve efficiency or to actually adapt to this new risk that were maybe underestimated, as some other people mentioned during previous session. So maybe then Natasja. Yeah.
Yes, and another comment, as other countries, I think this is pretty sure that M&A will definitely have an impact on MNE profit allocation, also for Switzerland. And the question is now, what will be the size of this impact? So it will depend on several factors, including a key one, so the definition of businesses that will be included in the scope. We also heard some discussion about the threshold, so it will for sure have an impact evaluate. It will have an impact on for Swiss MNE. So we are following the discussion of the OECD. We are also we have some working groups already working on Pillar 1 and Pillar 2, and we will see what will be the final results.
Yes, and then the last point that was not mentioned, but actually the LIBOR reference rate will disappear, will no longer exist. And this will have, of course, a big impact on the financial industry, but also on all intragroup financial transaction. And maybe I don't know if it's the reason, but at least in 2020, most of the ruling requests we got to deal with financial transaction, actually they included a fixed rate. So maybe it was something that they decided to go for fixed rate to anticipate this issue in the future. So that's it.
All right, thank you, Natasha and Thibaut, for this wonderful presentation. I think you've really given us a very good perspective on what's happening in Switzerland, both at the level of the separate entity approach and the Amount A allocation. Clearly, Switzerland's going to be impacted, and it's going to have an impact on the Swiss corporate tax base. That's obvious. Bruno, do you have any questions for Natasha and Thibaut at this stage? You know, any practical issues you see in practice between France and Switzerland relations, or anything like that?
A comment and two comments and two questions. The two comments are, I have observed in my practice that indeed Switzerland is, you know, before it was French reassessment leading to double taxation with Switzerland, and we opened MIP because of French reassessment. We start to have the other way around. I start to have reassessment made by the Swiss tax authorities leading to double taxation for French companies, which is interesting because it seems to me that indeed the Swiss authorities are indeed focusing on transfer pricing. First comment. Second comment on credit right. I heard what Thibaut said about this being a hot topic, the problems of using the databases that Moody's and Standard & Poor's and others offer. We have the same kind of issue in France. We have reassessment by the tax authorities criticizing the use of these. We have a lot of case law, and we're waiting for Supreme Court decision on this. It is a hot topic in France as well. So these were my two comments. On questions, my two questions are about what Natasha said about this TP team addressing ruling, unilateral APA, I understand. Is it something new, a separate team from the team which is dealing with MIP and then bilateral APA, in which there is Renato Salerno, for example? Is it a new dedicated team, or is it the same team?
No, it's actually another team. It's not the team that is dealing with the MAP and APA, bilateral APA. So it's a team that is at the level of the tax administration, federal tax administration, and the other team that you are talking about is the State Secretariat for Financial Matters. So it's two separate teams, and we are more dealing with the tax audit and unilateral APA, as we said. So maybe a comment in relation on what you said. So if you see that there are more adjustments also in transfer pricing done by Swiss tax inspectors, so maybe it's because of us. And
I don't know if I must say thank you. Okay. I understand more what's happening there. Okay.
Yeah, so that's my answer. And the second, you had a second question.
Well, you answered my second question, because I wonder whether for audits, my question was about rulings, and my second question was about audits, whether you had dedicated team or special support for transfer pricing, because indeed I see new audits on transfer pricing. Transfer pricing is a rather specialized item. In France, we created a special team focusing on transfer pricing, which assists the normal auditor. But I understand that your team is indeed doing that with the auditors. You are assisting them in, and that's why I understood they are now reassessment from a Swiss perspective. Okay.
Yes, exactly. We are supporting the tax inspectors, and they are doing the audit, and then we are involved also when there are TP issues. Exactly. So it seems that it's the same in France. So yeah.
Okay.
Thank you very much.
So I think I will move to the next presentation now, which is by Geert. And it's right at the topic. We're stopping at the topic when actually Natasja and Bruno have stopped at the topic, which is going to be picked up by Geert now, which deals with capacity building. Because you've seen in Switzerland now, there's a multifunctional, multidisciplinary team that has been created by the Swiss tax administration. And this is one of the topics which Geert is also going to address on the transparency and capacity building. So the floor is yours, Geert.
Okay, thank you, Vikram. And good afternoon, everybody. I'm glad you're still there because it's the final presentation. I know that's always a difficult one, but nevertheless, I'm very pleased you're all there. I will first give you a little bit background about me. I'm working on almost, I think, 30 years for the tax administration, but I used to be a transfer pricing auditor for about 10 years, but the last 5 years I'm working for the risk assessment. So we are working on the selection of cases. And what I mean with that, that's all about the international taxation. So the country by country reporting, so all about transfer pricing, but also about the tax rulings. And in the future, also the DAX 6 and the DAX 7 will come. So all those kind of exchange of information, we are doing the risk assessment. And I really like to do that. So that's about my background. So I will immediately start with the introduction. Indeed, it goes fluently under the things we have already been spoken about, because the webinar is titled Profit Allocation with Multinationals in the New Decade. And it seems to be at a crossroad, because on the one hand, we have heard it already a few times, we have the arm's length principle, and on the other side, we have the digital economy and also the global minimum tax. So there seems to be a problem, but is that so? So at first sight, it is the case. So, and of course, we know that arm's length principle, that is the separate entity approach with the local statutory accounts. And of course, on the other side, you have that group approach with more the consolidated accounts. So is it a conflict or what are we talking about? So please, the next slide, and I will go to the agenda. Yes. So I will first present you all the 5 important evolutions before reaching to the real challenge, I believe, and also to 2 solutions. And I will finally come to a kind of conclusion. But it will be, I think it's an obvious conclusion. But okay, we'll manage with that. So next slide, please. We have already heard this. Yes, next slide. This one. So we have already heard these last 2 days a lot of excellent speakers dealing about this first evolution. So I will not enter into too much details because I just want to give you that helicopter view and just to make my point. That's what I want to do, not too technical. So I think the simple fact is that we are moving from a pure transfer pricing approach to a wider international taxation scope, in which we will create more complexity. We have heard it already today as well. So I think that's the case. And how do I make my case? The first element is, of course, about the old TP world, and it has changed a lot these recent years. We have talked about the substance or the value creation. It has become an important issue for the profit allocation. And other good examples are also the delineation of the transaction, the DEMPE functions for the intangibles, and also the new guidance about the financial transaction. Amount B of Pillar 1, that's still in line with the arm's length principle, and is focused on reaching a fixed rate of return for those baseline marketing and distribution activities. But that's still in line with the arm's length principle. So the first 2, that's why I put them together, are still in line with the arm's length principle. And then if we move on, we have, of course, amount B of Pillar, amount A of Pillar 1. That's on the other hand, it's not based on the arm's length principle. And that allocates, as you all know, a part of the residual profit to the market or the user jurisdiction. And please keep attention, the word residual is not used here in the transfer pricing sense, it's used in another sense. And of course, we know that there the starting point are the consolidated accounts. Also, don't forget about the last, but also an important objective of Pillar 1, to improve tax certainty through effective dispute prevention and also some resolution mechanisms. So it's not only about taxation, it's also about avoiding a double taxation. And then Pillar 2, just a short one, it's also based on the consolidated accounts, and it ensures, of course, a global minimum tax as a whole. And it does so by, again, avoiding double taxation and to ensure that the transparency is there and also a level playing field. And then last but not least of the 5 elements, you also have all the other BEPS and ATAP measures to be dealt with. So those 5 elements, for me, it is clear that there will become more complexity. And the arm's length principle, it still remains, but if you see very globally, only 2 points are the arm's length principle and 3 points are not really arm's length principle. So indeed, I agree with what Richard said, that there is some pressure on the arm's length principle, but nevertheless, we have to deal with it. So please, the next slide. Another evolution is that we have more stakeholders dealing with tax. I do believe this is a good thing, but it is the case because we saw it. Now, in the past, we only had the taxpayer, the tax administration, and the consultants, more or less. But nowadays, this is no longer the case. We also have the investors, the public itself, also the media, the non-governmental organizations. They also have an important say to say about issues about tax. The next slide. Yes. Also, the third evolution, I call that, is that taxation is shifting internationally from a technical legal discipline to a much broader framework. And it's about a framework about sustainable development goals and also about environmental, social, and governance principles. Those are things created by the United Nations, but I do believe they become more important. And the idea is to come to a long-term sustainable value creation. So here again, you see that word in value creation. And I do believe value creation, like we see it also in transfer pricing happening, it becomes more an issue. Is it a good item? I don't know it, but at least we see something happening about value creation. But the main point I wanted to make here was that just profit maximization as such is no longer a goal on its own by the business. Business, of course, still wants to make profits, but only after first defining a kind of purpose for the business itself on the long term, also in a sustainable way. And then the profit comes as a result of that purpose. It's not just making profit anymore. It's about having a purpose and then making profit, of course, out of it. It's not the meaning that we make losses in the companies, but it's the meaning that we make profit, of course. So that's why all 3 P's, the people, planet, profit, they have been changed by replacing the profit element by prosperity. So that's another more or less approach. Profit is still in it, but in another way. I will first give a bit more explanation about the 4 pillars of the United Nations, about that sustainable value creation, and then I will give you 2 fine examples about that. So next slide, please. Yes, here we see the 4 pillars. So this is created by the World Economic Forum, and this is the first universal environmental, social, and governance reporting framework for sustainability and also non-financial information. And indeed, like I already said, there is some consensus among companies that long-term value is most effectively created by serving the interest of all the stakeholders. So it's not only about just one stakeholder, all the stakeholders needs to get their part of the game. And that's why they worked out a course set, and they call that the stakeholder capitalism matrix. So it's a matrix. And it discloses that it can be used to align the mainstream reporting on the performance against all those environmental, social, and governance indicators to obtain, of course, that sustainable development goals. So it's a kind of metrics. And I just wanted to point out 2 remarkable facts on that one, because I cannot explain all of them. And the 2 important one is that, like I already said, the profit pillar has been replaced with prosperity pillar, but in which taxes are included. So it's not just only about tax, but it's about prosperity. So it's a much broader way. And then also under the principle of the governance pillar, there are 2 new core metrics are added. So on the one hand, the setting of a corporate purpose, like I already said before, the corporate purpose, it should create value for all stakeholders. And on the other hand, there is also some kind of risk and opportunity oversight by integrating risk and opportunity into the business process. So also risk is becoming more important, and to deal with those risks. So that was the first about the 4 pillars. The next slide, please. Then we see the 2 practical examples. So the B team, I don't know if you know the B team. The B team stands for a plan B for business. So they created it, and there are quite some huge companies in that group. Okay, and what is their idea? Their idea, it exists of transparent, responsible tax strategies. And they practice out 7 responsible tax principles, which you see on the screen. I will only explain a few of them, because it will take me too much time to explain everything. But I just want to give you some inspiration to read afterwards, and then you can find it out yourself. So I'm just making some promotion on those principles, but I cannot explain them. It's too short my time. But nevertheless, you can read it afterwards. All the references are on the slides. And what are the most important principles? So they want to make board accountable for tax policy. That's a nice one, I think. Also publish tax strategy. Strategy having is fine, but you need to have a tax strategy and to be transparent about it. The next one is also the transparent about the entities who are owned around the world and why do you own them. And also some information about the overall effective tax rate. You know it, effective tax rate is becoming more and more important. So also there you can provide information about that. The next slide, please. That's the second example. Like I already said, that purposeful business, they call it now. That's the British academic who came up with that title. They're working already several years on it. And also there, I'm not going to explain every 8 of those principles. I will just explain some of them. And like for instance, and that's an important one, the corporate law should place purpose at the heart of the corporation. So that requires that the directors to state out their purposes and demonstrate commitment to them. So that's, I think, an important one, because then it is really embedded in the company itself. Another one who's also interesting, the one about ownership maybe. So the ownership should also recognize the obligations of shareholders and engage them in supporting corporate purposes, as well in their rights to derive financial benefit. So also there, I think that's an important one. I will not go through the other ones because it will take me too much time, but you see, the purposeful business, it has to be embedded in all the segments of a company. And I think that's the right way forward. And then you come to that profit at the end, but it has first a purpose, and then you have your profit. That's a new attitude. And I see, I'm from the tax administration, I see around me that business is indeed changing, and a lot of companies are going that way. And I do believe that is a nice thing to see. The next slide, please. Yes, and that's the 4th trend. That's about the tax transparency who is increasing. I will explain it by 2 examples. So next slide. So the first one is the GRI 207. Probably some of you have already heard of it, and I think more than heard of it, already implementing it. So GRI 207 was developed in response to the increasing demand from stakeholders for more and meaningful information on tax and risk management. And because we know it, the current standards for financial reporting, for instance, IFRS or local GAAP, it does not respond with respect to taxes. You only have consolidated tax data, but you don't have the real items you need to know. It's only consolidated. And therefore, we have some kind of new fiscal transparency created. And that's why we get that GRI 207. And it's very interesting because what do they need to report in those reporting? It is a description of the tax strategy, again, the tax governance, the control framework, as well as the risk management, the stakeholder engagement, and also, last but not least, the public country by country information. So you see, this is a really nice example of how those elements we have seen before here are being really transparent and being published to the public. I must admit, me as a tax administrator, we like to see those kind of things, but because indeed it is helping us a lot Because with those kind of information, you really get your starting point is from the business and not from the tax returns. Because you can always look at the tax return, but a much better position to do your audits or to do your risk assessment is starting from the business itself. And that's what we are doing with those kind of principles. The next slide, please. Because then we see the second example, that's VBDO. It's a Dutch company, and they make each year a tax transparency benchmark. And you can read the items or the titles they use. And the one thing is that I will only explain two of them. So first, you need to define and communicate a clear tax strategy. And I think that's again what we already seen before. You need really to explain what is your tax strategy. And that's a nice thing to have. And also the second one, tax must be aligned with the business and is not in a profit center by itself. That's also what we already seen in the previous one. It should not just being about making profit, but that purpose again. So again, here, it is nice to see that things are really changing. The next slide, please. And of course, it's not only the business who is changing, and I hope it is the case in all the countries, also the tax administration is changing. In the past, we still know that years before, we just had a paper-based organization. That's the version 1.0, that's long ago. Even in Belgium, we're also already at the 2.0. That's more the e-administration. So everything is dealt on, no longer on paper, but it's just communication on digital. It's not already, and that's what we want to arrive to, the 3.0. That's really the digital administration. But I must admit also in Belgium, we are working on that, but I think we are not already there. And so the digital transformation, because it goes a step further. I will immediately go to the next slide to explain it. Because what are the 6 core elements of a digital tax administration? And I will also explain only the first 2 ones. So it needs to be embedded within the taxpayer's natural systems. And natural systems, it sounds maybe a bit strange, but it is really in the databases of the taxpayer. So you're going to put all your some kind of transfer of data already in the taxpayer's ICT department. So that's really working. You don't longer have to send it by digital or by a form. You immediately have that kind of information. So that will be, I think, and they call that tax just happening. Yes, of course, tax just happening. But I think we're working on that, and this will, of course, facilitate compliance. They call that compliance by design. It's a nice word, I think. And then also the other one, that's also that being part of a resilient system of systems. And that's something we're already familiar with. Like we see it now. Nowadays, it can be that the VAT, that's digital platform, they will become agents. So also the VAT, as we know now, and then the digital platforms in the future, they will become agents for the tax administration. So they'll do the work for us. It's a kind of outsourcing. I will not explain the other ones because it will be taking too long. And then the next slide, because now we have seen the 5 evolutions, and then I want to come to the 1 challenge and the 2 key solutions. So next slide, please. Okay, so as you can read, so the challenge exists due to the increasing complexity of international taxation. There is a need for more tax certainty that's looking from the business side, but there is also a need from the administration side to have, we call that more tax secured. For me, that's the same wording, tax certainty that's looking from the business side and tax secured that's looking from the administration side. But the goal is the same. Both sides want to be sure that they've paid the right amount of taxes or received the right amount of taxes. So the need is the same. And I think there are only 2 solutions, in my opinion then. On the side of the business, there is a need to create even more transparency. But of course, it's upon the level of choice of the business itself. It's not because we want it or as a tax administration, it's upon the business itself to make the choice to become more transparent. And of course, also on the side of the administration, we also need to be more transparent about our willingness to come from an e-government to a really digital administration. Is that our willing or not? So also on our side, we need to be more transparent. And the second solution is that we need to invest more in the capacity building, because it's not only about, we need to have that for all those new international tax principles, I call it, That is, and this is the case not only for the business, but also for us as a tax administration. For me, there is no difference between the building capacity between the business or the tax administration. We're looking at the same things. So for me, I would like to see that we come to a kind of capacity building together with the business as with the tax administration. That would be a very nice thing to see. And then I will come to my last slide. No, not the last. Yes, if you can move the slide. That's about, yes, that's about, like I already said, we need to make choices about the level of transparency and also about that capacity building, how we will deal with that. And for me, I've put them together. So for the business, they have the choice to become, it can be non-compliant, of course, but I do believe if a business wants to be non-compliant, it's their good right. But of course, we know with the more increasing transparency, it will become much harder to do that in the future. And for us, because that's what we see, because we get a better risk assessment by having more interesting international exchange of information. And then we have new risk assessment, like artificial intelligence and also real-time evaluation. So it will be easier to trigger those cases for having an audit. But of course, and that's what we see also in our country, more and more companies, they want to be compliant. And compliant, that's also nice to have, but the upper level of compliance is still also the cooperative tax compliance. Then we're not working, that's an extra layer on it, because then we're also going to have that real-time tax certainty. Because with the compliant, you have also tax certainty, but not always on real time. With cooperative tax compliance, it is proactive and it's in real time. So that's the highest level for me of transparency. And of course, on our side for the tax administration, also we need to be clear about our transparency. So we are coming from an e-government, hopefully to a digital government, but we're still working on that. So you see, it's a data-driven approach. So it's not longer the old version, it is a data-driven approach. So, and then I will come to my conclusion. Yes. And yes, it's there. I lost my slide here, but okay, it's here. So for me, the first question was, are we on a crossroad? I don't believe we are on a crossroad. I do believe we are more on a highway. It is a broader highway, and it's a more complex highway, but still we're on a highway. And I do believe we will have more tax certainty in the future, because we have more legal instruments for that. But of course, we need also to work on that capacity building, because with that complexity, there is only one solution. I don't think we have to dream that it will become less complex. I only think it will become more complex. So we really need to do about something about capacity building. And that's why I also say in the slide, take the lead on transparency and capacity building. We have it in our own hands. So I do believe it's just a matter of dealing with those things. And that's what we also want to do, for instance, in Belgium. We want to build on that capacity building and also to do promotion on transparency and to get organizations doing that more transparent way. And I do believe that that will be a solution for the future. But there is only one trigger, and it's also on the slide. We need some kind of new skills. It's nice to have that EQ and that AQ, but I think the new one is the adaptability quotient. So we need to be resilient and also agile. And I think if we can go to that, I think we are ready for the future. So that was my conclusion. Vikram, over to you again.
Yeah, thank you, Geert, for this very nice presentation where you linked the entire profit allocation debate to an entire wide, you've linked the profit allocation debate to a more wider spectrum of the international tax system, especially when you start speaking about MNE profit allocation in light of sustainable development goals and with the focus on people, planet, and then improving the tax administration side. It was a excellent presentation. Richard, do you have any questions for Geert? But let's try to have a discussion for 3 minutes because we're already running 10 minutes past the allotted time to us. So a quick question for Geert on his presentation.
I'm not sure I have an immediate question. I'm intrigued that you think we're going to manage the complexity. You seem optimistic about managing the complexity. which is good to hear. So maybe that's just a comment. That's what struck me from certainly your recent comments, is that optimism about managing complexity. I think a number of people are maybe I'm more concerned about managing the complexity going forward. So maybe it's just a comment.
Yes, so we see different perspectives here, but I think what we will do is we will end our session now. So I would really really like to thank all the speakers, Richard, Bruno, Thibaut, Natasja, Geert, for their wonderful presentations and the stimulating debate that we've had.